Hello, this is Mr. Seymour, and this set of lecture slides from American Politics Today is going to cover Civil Liberties, Chapter 4 of your textbook. Should freedom of religious expression be protected even when acting on those views means discriminating against someone else? In general, discrimination based on religious views is not allowed. But Rowan County Clerk of Courts Kim Davis served time in jail for contempt of court after she refused to follow a court order to issue marriage licenses to same-sex couples. So was she discriminated against on the basis of her religion, or was she found guilty of contempt of court because she didn't follow the order of the courts? You see, there's a line that can be crossed in between our individual rights under the Bill of Rights and our liberties or freedoms. Civil liberties are basic political freedoms that protect citizens from government and abuses of power. The public's demand for Social Security after September 11th came into contact with the Constitution's protections of civil liberties in a dramatic way. As part of the war on terrorism, the government engaged in extraordinary rendition. Suspected terrorists were taken from their homes or airports, arrested, taken for questioning to countries that are less protective of civil liberties, like Egypt, Syria, Jordan, or Morocco. If they failed to give useful information, they would be beaten, kept in tiny cells, shocked with cattle prods, and waterboarded, which is simulated drowning. This raises the question of what happens when the wrong person is taken into custody. An equally compelling example comes from Edward Snowden's revelations about the extent of National Security Agency NSA spying on both American citizens and foreigners. Where do we draw the line between the need for security and the right to privacy? There is no clear answer on how to balance civil liberties and national security. If we accept that some situations, such as imminent terrorists, detonated nuclear attacks, dirty bombs, or even another 9/11, might require sacrificing civil liberties in order to stop, the question becomes how much and under what circumstances do we prohibit or inhibit someone's civil liberties? The fundamental problem of civil liberties is how to balance competing interests, like personal liberty, with security or military strategy. We have to distinguish between civil liberties and civil rights. And there's a video that I've included in the in your lessons this week on distinguishing between human rights and civil rights. So I want you to make sure you watch that video. Civil liberties are basic freedoms and liberties. We generally find these in the United States in our Bill of Rights, but not every country has a Bill of Rights, nor does the Bill of Rights of every country say the same thing. Civil rights are protection from discrimination, and we generally look to the 13th, 14th, and 15th Amendments for civil rights. Civil liberties are rooted in the Bill of Rights and the due process protection of the 14th Amendment. Civil rights are rooted in laws and the Equal Protection Clause of the 14th Amendment. Civil liberties primarily restrict what the government can do to you. Congress shall make no law abridging the freedom of speech, for instance. Civil rights protect you from discrimination, both by the government and by individuals. So civil liberties are more about the individual. Civil rights are more about groups of people. And civil liberties are more rooted in the Bill of Rights. Civil rights are more rooted in the 13th, 14th, and 15th Amendments. The process applying the Bill of Rights to the states progressed in two stages. The first, coming in the 1920s and 30s, applied the First Amendment to the states. The second came a few decades later and involved criminal defendant rights, but both of them looked at the same amendment to the Constitution in order to have the power to take the United States Bill of Rights and to force states to compel to the United States Bill of Rights. Before the 1920s, the United States Bill of Rights was considered to be something that states were not required to do. They had to stay with their own Bill of Rights, and the National Bill of Rights was for federal action. The process through which civil liberties granted in the Bill of Rights were applied to the states on a case-by-case basis through the 14th Amendment is selective incorporation. The Due Process Clause of the 14th Amendment forbids any state from denying life, liberty, or property without due process of law. Using the 14th Amendment, we progressed in two surges, including the 1920s and 30s and the 1960s. The Bill of Rights has evolved from the 19th century's limitations that affected only national government action to a more robust set of widespread protections for freedom and liberty. Now, this Table 4-1, which is in your textbook, is a listing of the rights from the Bill of Rights that have been incorporated. The First Amendment, freedom of speech, was incorporated through a court case, Gitlow versus the State of New York, 1925. Freedom of the press was incorporated by a court case, Neer versus Minnesota, 1931. Freedom of assembly, DeJong versus Oregon, 1937. The right to petition the government was Hague versus the CIO, 1939. The free exercise of religion is Hamilton versus the Regents of the University of California in 1934 and Cantwell versus Connecticut in 1940. The separation of church and state, Everson versus the Board of Education of Ewing Township, 1947. All of these deal with the First Amendment and taking the First Amendment rights and bringing them down to the states. The Second Amendment, the right to bear arms, does not get incorporated until 2010. This is the latest of the amendments to be incorporated in a case called McDonald versus Chicago. The Fourth Amendment, protection of unreasonable search and seizure, is incorporated in two cases, Wolf versus the State of Colorado in 1949 and Mapp versus the State of Ohio in 1961. The Fifth Amendment, protection from forced self-incrimination, is enforced by Mallory versus Hogan, 1964. The protection from double jeopardy is enforced by Benton versus Maryland, 1969. The Sixth Amendment, the right to a public trial, R.E. Oliver, 333 U.S. 257 of 1948. The right to a fair trial and an attorney in death penalty cases is Powell versus Alabama, 1932. The right to an attorney in federal cases, Gideon versus Wainwright in 1963, which is a very important case. The right to an attorney in cases involving jail time is Argensinger versus Hamilton in 1972. The right to a jury trial in a criminal case, Duncan versus the State of Louisiana, 1968. The right to cross-examine a witness, Pointer versus Texas, 1965. The right to compel the testimony of witnesses who are vital for the defendant's case, Washington versus Texas, 1967. So the majority of these Sixth Amendment rights, as well as Fifth Amendment rights and Fourth Amendment rights, a lot of them come from the 1960s and the late 1940s. This is the second wave. The Eighth Amendment, protection from cruel and unusual punishment, Robinson versus the State of California, 1962. Protection from excessive bail, Scheib versus Cable, 1971. The Ninth Amendment, the right to privacy, and other non-enumerated fundamental rights is Griswold versus Connecticut, 1965. So Griswold is considered the case that deals with the right to privacy, and they use the Ninth Amendment, and this is an abortion case. Now, not incorporated. There are 4 of the Bill of Rights that are not incorporated. The Third Amendment, the prohibit against quartering of troops in private homes, is not incorporated. Part of the Fifth Amendment, the right to indictment by a grand jury, is not incorporated. Some states have grand juries, some states have preliminary hearings. Seventh Amendment, the right to a jury trial in a civil case, is not incorporated. The Eighth Amendment, prohibition against excessive fines, is not incorporated. How can conflicts be resolved between civil liberties and other legitimate interests such as public safety and public health? Sometimes freedom is forced to give way. Courts have upheld bans on the religious practice of snake handling and laws requiring the Amish to display reflective triangles when driving slow-moving buggies on public roads, despite religious objections to do so, because the state considered these to be a part of the public good. So, in theory, how does this work? The First Amendment has 2 parts, freedom of expression and freedom of religion here, as well as freedom of assembly. Freedom of assembly, freedom of petition, freedom of the press, and freedom of speech are all part of the freedom of expression. Freedom of religion has 2 parts, Establishment Clause, which is the government cannot establish an official religion or favor one religion over another, and Free Exercise Clause, which says the government cannot prevent people from practicing their religion. So in the book, they're taking the freedom of expression and breaking that into freedom of assembly, freedom of petition, freedom of the press, and freedom of speech. They're taking freedom of religion and bringing it into 2 parts, the Establishment Clause and the Free Exercise Clause. Then we have to look, for instance, in freedom of speech to less protected forms of speech, as well as the idea of political speech and symbolic speech. So we break things down even how it works in practice. We must balance the interests of the Bill of Rights, but at the same time draw lines. For instance, government and religion. When Kim Davis, the county clerk, refused to issue marriage licenses to same-sex couples, was she freely exercising her religious beliefs? Was that protected by the Free Exercise Clause? The court said no. The court ruled that her religious convictions did not allow her to discriminate. And here's why. In cases like these, courts must balance religious freedom with other state and national interests, such as freedom from discrimination. The Establishment Clause bans, for instance, school prayer as a violation of the Establishment Clause, and has since 1962 the Supreme Court has banned school prayer. But what about separating church and state in a prayer meeting before a city or town board meeting? Does the separation of church and state apply to town board members who start their meetings with a prayer? In 2014, the court decided by a 5-4 vote that it did not. It's a tough decision, though. The Establishment Clause often asks courts to draw lines between what types of religious conduct is allowed and what would be considered an excessive entanglement between church and state. The Bill of Rights comes from the actions of anti-federalists who argued that the national government, as established in the Constitution, would be too powerful without protections for individual rights. the Bill of Rights was added to the Constitution, thus winning the support of anti-federalists necessary for ratification. Prior to the Civil War, the Bill of Rights applied only to the national government and did not protect citizens in the 18th century to the degree that it does now. For instance, look at the case of Barron versus Baltimore. This is important because in the first 80 to 100 years of our nation's history, states had much more power than the federal government did. That was the era of layer cake federalism, remember? The 13th, 14th, and 15th Amendments, called Civil War Amendments, to the Constitution, abolished slavery, granted civil liberties and voting rights to freed slaves after the Civil War. The 14th Amendment, which guarantees equal protection to all American citizens, regardless of state of residence, is particularly important for civil liberties. The Due Process Clause, which is the part of the 14th Amendment that forbids states from denying life, property, or liberty or property to any person without the due process of law, is a nearly identical clause to one that's in the Fifth Amendment, which applies only to the national government. The case of Gitlow versus New York was the first case that found that the 14th Amendment incorporated certain amendments of the Bill of Rights, in this case the First Amendment, meaning that states were not free to violate those rights. Selective incorporation is the process through which the civil liberties are granted in the Bill of Rights and are applied to the states on a case-by-case basis through the 14th Amendments, and those rights are protected by selective incorporation. They are sometimes called the honor roll of superior rights. Now, this is the Bill of Rights. The First Amendment giving the right of religion, speech, press, assembly, and separation of church and state, and the right to petition government. The Second Amendment is the right to bear arms, which would be to own a gun. The Third Amendment, the protection against the forced quartering of troops in one's home. The Fourth Amendment, the protection from unreasonable searches and seizures and a requirement of probable cause for search warrants. The Fifth Amendment, protection from forced self-incrimination or double jeopardy, being tried twice for the same crime. No person can be deprived of life, liberty, or property without due process of law. This is an almost identical clause to the one that's in the 14th Amendment. Private property cannot be taken for public use without just compensation, and no person can be tried for a serious crime without the indictment of a grand jury at the federal level. The Sixth Amendment, right to the accused to a speedy and public trial by an impartial jury, to an attorney to confront witnesses, to a compulsory process for retaining a witness in his or her favor, and to counsel in all federal cases. So in other words, the right to a lawyer and the right to face your accuser. Seventh Amendment, the right to a trial by jury in civil cases involving common law. Eighth Amendment, the protection from excessive bail, excessive fines, and cruel and unusual punishment. The Ninth Amendment, the enumeration of specific rights in the Constitution, cannot be construed to deny other rights retained by the people. This has been interpreted to include a general right to privacy and other fundamental rights. So your right to privacy, if there is a right to privacy, is under the Ninth Amendment. But it doesn't specifically give you a right to privacy. It's interpreted as giving you a right to privacy by the courts. The 10th Amendment, powers not delegated by the Constitution to the national government, nor prohibited by it to the states, are reserved to the states or to the people. Although you may have heard the phrase about a wall of separation between church and state, this phrase is not in the Constitution. It comes from an 1802 letter from Thomas Jefferson to the Danville Baptist Church. And in understanding where to draw the line between church and state today, one can imagine the court's decisions on a spectrum, from separationist, which is a hard line between church and state, to accommodationist, which is allowing religious activity in public institutions. Many controversies surrounding the church and state involve what children are taught in public school or whether children are allowed to pray in school. Compulsory prayer was prohibited in 1962 and 1963 in the cases of Ingle versus Vitale and Abington versus Schempp. To what extent are religious organizations allowed in public spaces? For instance, can a town have a creche, a living Christmas tree, or a living nativity scene in its village square? What if the town were to sponsor a Christmas pageant? Does it make a difference if the town were to spend significant funds on the pageant? To answer these questions, the court developed what's called the Lemon Test. The Lemon Test comes from the case of Lemon versus Kurtzman. The Supreme Court uses this test to determine whether a practice violates the First Amendment's Establishment Clause. The test claims that any government aid must have a secular purpose, does not advance or inhibit religion, and does not foster an excessive entanglement between government and religion. The Lemon Test has not been totally dropped, but the court is moving away from it towards an increasingly accommodationist perspective. For instance, in Zellman versus Simmons and Harris in 2002, the court ruled that the tuition vouchers given to parents do not constitute impermissible state support of religion. Dissenters, however, argue that this is the first time that public dollars, excuse me while I catch up with myself here. This is the first time that public dollars were being used for employees of a particular religious organization. In this case, most of the vouchers were used to send poor children to Catholic schools. But the court's majority argued that the program was constitutional since the aid went to parents and not the schools. But they do go to the schools indirectly. The free exercise clause can be more difficult to interpret, but essentially you can believe whatever you like. But if you act on your beliefs, the government might be able to regulate your behavior. After lawsuits brought by Jehovah's Witnesses who believed that reciting the Pledge of Allegiance violated their religion, requiring the recitation of the Pledge of Allegiance is now unconstitutional. Congress and the court are going back and forth over whether the court now needs to have a compelling interest to regulate its religious practice. The court thinks it doesn't need to have a compelling interest. What exactly would that mean? But just a good one. Interestingly, the Religious Freedom Restoration Act of 1993 and the Supreme Court decision of União do Vegetal allow certain exceptions of the Controlled Substances Act. These carve-outs allow members of certain Indian tribes to use peyote and certain religious sects to drink hallucinogenic tea as a part of religious rites. Another recent case dealt with whether a law school could require an on-campus student organization, the Christian Legal Society, to accept members who had views that differed from the organization's belief. The court ruled that the school could withhold student funds if the group discriminated in who it allowed as members. So a non-Christian could join this Christian group, for instance. So the Establishment Clause is the part of the First Amendment that states, Congress shall make no law respecting an establishment of religion, which has been interpreted to mean that Congress cannot sponsor or endorse a religion. The Free Exercise Clause is the part of the First Amendment that states that Congress cannot prohibit or interfere with the practice of religion. Freedom of religion, freedom from religion. Here, demonstrators outside the United States Supreme Court are here during oral arguments in the 2014 Hobby Lobby case. The court ruled that a for-profit corporation, Hobby Lobby, may exclude contraceptives from their employer's health insurance, which is otherwise entitled by federal law, based on the religious objections of the corporate owners. So Hobby Lobby won this case and is able to say, no, we're not going to pay for something we don't believe in because of our Christian values. Can a cross be displayed on federal land? The Supreme Court has ruled that religious displays on government property must be part of larger secular displays. This cross on federal land in the Mojave Desert was covered up after it became controversial. Now it looks like a sign. In this picture, Senator Joseph McCarthy is standing in front of a map purporting to show communist activity in the United States. McCarthy was a central figure in the post-World War II Red Scare, during which Americans suspected of supporting communism were persecuted and imprisoned. The Alien and Sedition Acts were an example of a restriction on political speech. They would not be the last. During World War I, Congress passed the similarly named Sedition Act of 1918, which outlawed any disloyal, profane, scurrilous, or abusive language about the form of government, the Constitution, soldiers and sailors, flag and uniform of the armed forces. An interesting figure in the transition from the old restrictive view of freedom of speech to the new permissive view was Oliver Wendell Holmes. In a case against an anti-war pamphleteer, Schenck versus U.S., Holmes develops the clear and present danger test, which allows the government to restrict certain types of speech deemed dangerous. In arguing for this test, Holmes analogized dangerous words to shouting fire in a crowded theater. In future cases, Holmes would be persuaded that we should be eternally vigilant against attempts to check the expression of opinion that we loathe and believe to be fraught with death. In this sentiment, he is advocating for a free trade of ideas. The free speech test was replaced with the direct incitement test, established in Brandenburg versus Ohio. This test protects speech under the First Amendment unless it is directed at inciting imminent lawless action and is likely to incite or produce such action. For instance, it's one thing to say, down with the ROTC. It's another to say, let's go burn the ROTC building down. Students are only sometimes protected by direct incitement. In a bizarre case, Frederick V. Morse, a student who cut school to attend the March of the Olympic Torch through his hometown, was punished by his school when he raised a Bong Hits for Jesus banner. The student wasn't trying to make a point. The banner was supposed to be a joke, although he tried to argue that his speech was partially protected by the ruling in Tinker versus Des Moines, which ruled the students did have a right to wear a black armband to class to protest the Vietnam War. The court found for the school district and ruled that his speech was not protected. The takeaway lesson is that freedom of speech does not always apply to students talking about drugs in school, because drugs in school is a safety issue and a public health issue, and it is believed that the schools should have the power to regulate such talk. The American flag is a popular target for protesters. It has been spat upon, shredded, turned into underwear, and burned. Here, protesters burn a U.S. flag as they march through a downtown Washington, D.C., following the Ferguson, Missouri grand jury decision not to indict Officer Dean Wilson for the shooting death of Michael Brown. Flag burning is symbolic speech. It is nonverbal expression. Symbolic speech is a nonverbal expression, such as the use of signs as symbols. It benefits from many of the same constitutional protections as verbal speech. Congressional regulations over campaign contributions have been repeatedly overturned by the Supreme Court. Initial attempts at regulating money in politics took place in the 1970s, but were overturned by the court in Buckley versus Vallejo in 1976. After the 2004 elections, portions of the Bipartisan Campaign Reform Act of 2002, the BCRA, or McCain-Feingold Act, were also overturned by the court. More recently, the court has further expanded the role of money in politics in 2010 when it ruled that corporations and unions were protected by the First Amendment. Spending money in political campaigns is protected by the First Amendment at present. The court balances two values in making this decision. First, the public interest in honest and ethical elections. Second, the First Amendment right of candidates and their advocates. Hate speech. Are laws banning hate speech constitutional? Sometimes yes, but the threshold is relatively high. These KKK members are free to hold rallies, preach racism and xenophobia, and burn crosses as long as they do not directly incite violence or display an intent to intimidate. In other words, burning a cross on someone's lawn. Hate speech is an expression that is offensive or abusive, particularly in terms of race, gender, or sexual orientation, and is currently protected under the First Amendment. In the center of this picture is Bradley Manning, who has now become Chelsea Manning, whose job in the U.S. military gave him access to classified information. He downloaded thousands of classified videos, diplomatic cables, reports, and other information, and then gave them to a website called WikiLeaks. Now, prior restraint, when it comes to freedom of the press, is a limit on the freedom of the press that allows the government to prohibit the media from publishing certain materials. The Supreme Court looks unfavorably on government attempts to restrain the media. So, telling the media that they can't publish something is generally frowned upon. That is called prior restraint, because we have freedom of the press. Joe Camel peddles his wares on a New York City billboard. Commercial speech as a general category is not strongly protected by the First Amendment, is not as strongly protected as political speech. But advertising can be limited by the government only on specific circumstances. And as in Joe Camel, because Joe Camel was appealing to youth. Commercial speech. It has become much tougher to regulate commercial speech in our era, though ads can be regulated if they meet any one of three criteria. Number one, they concern an illegal activity. Number two, they are misleading. Number three, regulation advances a substantial governmental interest. And it was felt that regulating, for instance, Joe Camel here, advanced a substantial governmental interest, especially in keeping youth from smoking. While the Constitution guarantees the individual rights to bear arms, as shown by the woman taking target practice, the shootings at Umpqua Community College in Rosenberg, Oregon, shocked the nation. In response, college students organized a demonstration on Capitol Hill urging Congress to vote for gun reform. Texas, on the other hand, just allowed concealed carry on college and community college campuses. So we are very much a Second Amendment state. The Second Amendment reads, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, this has been very liberally interpreted under today's rulings with the Supreme Court to say that unless there's a compelling reason, individuals are allowed to carry and own guns. This particular picture says, what's wrong with background checks? Stop the carnage. Some people agree that we need to have certain restrictions, like a background check. Others believe that we should have no restrictions. The Constitution provides numerous protections for those accused of crimes. Once again, we are asked to decide how to balance the rights of the accused with the desire for a safe and orderly society. This is particularly salient or important in the wake of September 11, 2001, as we balance civil liberties against the need for national security. And the best example of this, of how tricky this balance can be, is the USA Patriot Act. Due process rights are designed to protect the rights of the people who have been accused of a crime. These are the 4th, 5th, 6th, and 8th Amendment, and they include protection from unreasonable search and seizure, the right to a fair trial, the right to consult a lawyer, freedom from self-incrimination, knowing what crime you're accused of, and the right to confront your accuser. The 4th Amendment protects us from unreasonable searches and seizures. But what's unreasonable? For instance, the Patriot Act authorizes roving wiretaps where a single warrant allows law, surveillance, and investigation of all forms of communication with a suspected terrorist, and sneak and peek searches wherein police enter a home, look for evidence, and do not tell the suspect that they've been there. Typically, fishing expeditions are not allowed. These are exceptions, including school lockers. In 2003, gun-wielding police burst into a Goose Creek, South Carolina high school and ordered students to lie down in the hallways as they used dogs to search for drugs. This commando-style raid, caught in the school surveillance cameras, outraged parents around the country and made them question the wisdom of police tactics. No drugs or weapons were found during the sweep and no charges were filed. Following this operation, the American Civil Liberties Union, or ACLU, brought a lawsuit on behalf of the students' families, charging police and school officials with violating students' rights to be free from unlawful search and seizure and the use of excessive force. The school district ultimately granted the students a monetary settlement and agreed to change its policies on drug raids. But what happens if evidence is obtained illegally? The exclusionary rule means that fruit from the poisonous tree is inadmissible in court. However, good faith exceptions allow courts to consider the totality of the circumstances, meaning that the exclusionary rule doesn't always throw out evidence. For instance, if the police come across a scene and someone is holding a knife, they don't have to have a warrant to seize that knife. It's obvious that that knife has been used in the course of the crime. But what happens if there are exigent circumstances? The police come to the door, they've been called, and they've been told that there is a domestic dispute going on and someone has a weapon. And they hear help, help from the other side of the door. Do the police have the right to knock the door down? Do they have probable cause? These are called exigent circumstances, and it's a good faith exception. Probable cause is needed to obtain a search warrant. The restriction is relaxed in schools or when consent of the searched. The exclusionary rule says that illegally obtained evidence cannot be used in a trial. The exclusionary rule has been weakened, though, over time. Can the police search your home without a warrant? After Doultree Mapp was arrested for possession of pornographic material, the case made its way to the Supreme Court, and the search was ruled unconstitutional. This case established the exclusionary rule for evidence that is obtained without a warrant, the Mapp versus Ohio case. Here, federal agents use a drug-sniffing dog to inspect a car. A citizen who pleads the Fifth invokes the right to remain silent if answering questions would lead to self-incrimination. This is the most famous part of the famous Miranda warning. You have the right to remain silent. The Supreme Court's requirement that subjects be read the Miranda warning, also known as being Mirandized, preceded an era in which crime spiked in America. Whether this was a case of cause and effect or merely a coincidence, the Supreme Court backed off the expansion of civil liberties, or coddling criminals, as critics alleged, and carved out exceptions for security. Exceptions include allowance for public safety and for inevitable discovery. A recent case weakened Miranda by requiring a suspect to actively invoke the right to remain silent, while a different case strengthened by Miranda by limiting common police practices of getting a confession, then reading a suspect their rights, and getting a second confession. Another famous aspect of the Fifth Amendment is its prohibition of double jeopardy, being tried twice for the same crime, which is forbidden in the Fifth Amendment. There are two loopholes to the prohibition on double jeopardy. People can be acquitted on criminal charges but found guilty on civil charges, and they can be tried in federal court and state court for the same crime. As the number of federal crimes has increased exponentially, the second loophole is becoming troublesome to many civil libertarians. And this is an issue where the federal government will decide to file federal charges. If, for instance, you got off on murder on state charges, you could be tried on federal charges of prohibiting someone's civil rights, the right to life. This is a typical example of a Miranda warning card that police officers carry with them and read every suspect after an arrest. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to an attorney and to have them present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish one. And then you're required to sign it, and then it's witnessed. If you refuse to sign it, then they mark it refused signature. In Gideon versus Wainwright, Clarence Gideon was accused of breaking into a pool hall and stealing beer, wine, and money from a vending machine. Since he was poor, he could not afford an attorney, and he defended himself. Ultimately, the court overturned his conviction, stating, "In our adversary system of criminal justice, any person haled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for." To learn more about this case, look at Gideon's Trumpet, which is a book and a movie. And I'll put a link to the movie Gideon's Trumpet for you. You don't have to watch it, but you'll like the movie. The right has been strengthened over time by both Congress and the court. Congress passed the Criminal Justice Act, which better protected poor defendants the year after the Gideon decision. And the court has since defined a general right to effective counsel. Certain defendants have successfully appealed their convictions on the basis of ineffective counsel from a public defender. Look at the Supreme Court case of Strickland versus Washington or Padilla versus Kentucky. The Sixth Amendment also guarantees the right to a speedy and public trial in front of an impartial jury. What constitutes a speedy trial, though? According to the 1974 Federal Speedy Trial Act, a trial must begin within 70 days of the date of arrest. And what's an impartial jury? The issue is blurred by the court, but the court has ruled that it has to do with jury selection and preemptory challenges. These allow attorneys to eliminate prospective jurors, which must not be made on the basis of race or gender. Because of the right to trial by jury, the court has struck down several forms of mandatory sentencing that require judges to impose sentences based on facts other than those confessed to by a defendant or proved to a jury beyond a reasonable doubt. The fight against terrorism has raised controversial questions about due process rights. After the United States killed Anwar al-Awlaki, an al-Qaeda leader living in Yemen and a foreign U.S. citizen, he was a citizen of the state of New Mexico. He went to New Mexico State University, by the way. Critics argued that his due process rights, such as the right to a fair trial, had been violated. In the past decade, the court has reversed course by banning the death penalty for the mentally retarded in 2002, people of a minor age in 2005, and child rapists in 2008. Founders would be surprised that the amendment is applied to the death penalty after all. The 5th and 14th Amendments note that one cannot be deprived of life without due process, so we can infer that one could be deprived of life if there was due process. Proportionality examples include punishments such as stripping the accused of citizenship and incarceration for drug addiction. Laws like California's 3 strikes and you're outlaw, which might involve harsh punishment for mild third crimes, have been found constitutional. The death penalty is legal, though there are restrictions. The court has increased the number of restrictions on the death penalty in the past 20 years. These are the things you need to know. The court ruled that the 1st, 3rd, 4th, 5th, and 9th Amendments all imply privacy rights in various forms, and thus certain parts of citizens' lives ought to be shielded from government. The Griswold decision paved the way for the landmark Roe v. Wade decision, which struck down state limits on abortion. This is also the basis for gay rights and same-sex marriage laws. Tyron, Garner, and John Geddes Lawrence, after the Supreme Court decision in Lawrence v. Texas below in 2003, established broad privacy rights for sexual behavior, including homosexual behavior. Believe it or not, prior to 2003 in the state of Texas, it was illegal to have homosexual sexual relations. It was there were sodomy laws, so these overturned the sodomy laws. The court's 1973 decision in Roe v. Wade made abortion legal throughout the United States. How do abortion rights look today? What do the numbers say? And you'll see this in your What Do the Numbers Say section in your activities for this lesson. But you'll see that a number of states have put in laws requiring mandatory waiting periods, requiring, in Texas, for instance, it is a requirement that you have to see a doctor and have a ultrasound taken before you can have an abortion, and it's illegal. It's actually a capital crime. You can be executed for performing an abortion on a minor without parental consent in Texas.